Ahmet and Tatum and another.
Mr. Warwick.
My lords, in this matter I appear with Eleanor Vickery as my junior. The Crown Prosecution Service, the CPS, is represented by Martin Evans, King's Counsel, and Anna Keithley. Mr. Tatum, who I believe is to our right, is not represented. This is an appeal against the order of Mr. Justice Michael Green, with permission granted by Lord Justice Arnold, and quoting in part from what he said, because of the importance of the issue. So what is the issue on the basis of which he granted permission to this court? The learned judge, in a very clear way, expressed it in his form N460, which is in the main bundle at page 80, and he said, in the result of the hearing, about 2/3 of the way down in the box, proceedings struck out as an abusive process because Parliament has decided in the Proceeds of Crime Act, which I will call POCA from now on, that disputed property interests in the context of restraint and confiscation proceedings should be determined in the Crown Court. And
possibly the waters get muddied slightly when he gives his reasons on the next page, where he refers to an evaluated non-factorial assessment.
Yes, but we don't necessarily have to stop, and I wasn't going to stop at that point. I was going to also take you to paragraph 33 of the judgment, which is page 71 of the same bundle. And this was the submission that Mr. Evans made, which the judge accepted. And I see this as the issue which I'm going to be tackling today. Of course, there may be those who disagree with me, but that's how I'm intending to deal with it. And he says at 33, it does seem to me, in accordance with Mr. Evans' submissions, that Parliament has provided a complete and exhaustive code for the resolution of disputed property rights in the context of restraint and confiscation orders in criminal proceedings. Third-party rights are fully protected by ensuring that at each stage the third party is able to argue in support of their alleged beneficial interests in the property concerned. And that, so whatever else he might have said in that form, this was the key submission that Mr. Evans made, which the judge accepted. And I perceive that the bigger importance of this case, I don't derogate from the significance to my own client, but the bigger significance is the many circumstances in which third parties have interests in a property, which property will fall within the scope of POCA. And then there can be months, indeed years, before there is a trial. One of the things, it's only one of the things that can happen, is that that trial results in an acquittal, and therefore any restraint order is discharged. If the judge is correct in the view he accepted, then the exclusive forum for any dispute regarding that property is the Crown Court, and that the third party, whoever it may be, has no redress in the civil courts. And so you'll hear me say a little bit later that that means that these third parties have to sit around and wait whilst criminal proceedings take place. A study of the judgment shows that the judge's decision on the issue, which is, as I called it, was arrived at because of the CPS prompting. He gave POCA too wide an effect. There are at least 5 references which I'm going to mention now, and I'll be picking up when I go through POCA, which I will do in a little detail shortly. If we go back to the judgment, you're probably there already. So we start with page 67, paragraph 19, where, setting out the background, the judge says, the CPS then applied for a confiscation order under section 6 of the Act. A timetable for evidence has been set, leading to a hearing in the Crown Court, listed the 13th of October 2023. The claimant has the right to intervene. So we'll be having to look at the Act to see whether it refers to a right to intervene. It says, has the right to intervene in the confiscation proceedings to protect her beneficial interests. Instead, she's chosen to proceed in this court. If you turn over the page, 23, where there is a confiscation investigation, as there now is in this case, the Crown Court can make orders for disclosure, search and seizure of warrants and production orders, see so and so. A third party, such as the claimant, may be joined to the confiscation proceedings as a party. So related to what we've just seen, we'll be looking to see whether that's what the Act provides, so as to establish the defendant's interest in property. They will also bind the third party to the decision. Turn over the page, paragraph 26, and this is a point that the judge did grapple with. Bottom of the page, Mr. Warwick relied on the use of the word may, this is in section 10A of course, as indicating the Crown Court is not being given exclusive jurisdiction to determine those property interests, leaving the door open to the High Court to do so. I do not read it that way. It is leaving the Crown Court to decide whether it wishes to deal with such issues at that stage, that is, as part of the confiscation proceedings, or maybe to leave it to a later stage, such as enforcement, which may be a more appropriate time to consider those matters. So that is plainly going to be one of the matters we'll be discussing 10A, but there are other provisions in the Act which are also pertinent we'll be having to look at. Then, if I go to the next reference, which is looked at 31, yes, and I should have, I've missed out. No, that's 26. Then if we go on the same page, 28, page 70, the court is required to determine as between the defendant and any third party the value of their interest, and if so, where relevant, the extent of each of their beneficial interests. Any third party joined to the proceedings, so that's the joinder point, has a right of appeal to the Court of Appeal, see section 31(4). I wonder
if we can address this in some way. I mean, plainly, it's right that Mr. Tatum should be able to contribute at some point, should he wish to.
He should be muted.
But can he be muted? Who has control of?
I can speak.
Sorry.
So, sorry.
I can hear and speak.
If it's possible, can we get you to mute your microphone?
Muted, sorry.
Thank you.
Thank you very much.
That's very helpful. Yes, so I was on 28, a reference to the right of appeal. We will see when we look at the provisions that the right of appeal has some limits, which you wouldn't have if we were dealing with civil proceedings. And then 31, which is a sort of duplication of something we've already seen. So once again, at the latter stage of the process, the third party is given the right to intervene to protect their beneficial interest in property that may be sold. And then over the page, it talks about a right of appeal is preserved. And again, I'll be looking at the right of appeal in that particular subsection to see that it is a fettered right of appeal. And so those particular paragraphs obviously lead up to his statement in 33. So what I'm going to be telling your lordships, sorry, I'm putting that too strongly, what I will be submitting to your lordships is, one, let's see what POCA has to say. Does it really have the content that the judge was reflecting from Mr. Evans's submissions? Secondly, consider the general jurisprudence as to what I'll call the exclusive jurisdiction principle, and ask whether POCA does give the Crown Court the exclusive jurisdiction that he so decided at paragraph 33 of his judgment. And thirdly then, this is probably part of the reason why Lord Justice Arnold gave his permission, look at the various cases that are concerned with POCA and its predecessor. There are in those cases carefully considered dicta in a series of decisions of this court that we say are contrary to the judge's statement in his judgment at paragraph 33. And in order to uphold, or rather to dismiss the appeal, your lordships will be having, I suggest, to consider and decide that those dicta are actually wrong in the context they're given. So those are the three stages I'm going to be following. And right at the very end of my submissions, I'll make one or two comments about the facts of my case, but I'm really focusing on the issue of principle as we go along. So the first stage in my approach is to actually look at POCA. That means probably from now on, putting aside the references to the core bundle and taking up the bundle of authorities, as Mr. Holt has, and it's been provided at tab 1 for those who've got hard copies, which is me being old-fashioned. Tab 1, there's a copy of POCA, and I'm going to go through provisions. I'll try not to leave anything material out as I go through. So section 6 is the provision for the making of confiscation orders. Subsection 1 tells us that the Crown Court must proceed under this section if 2 conditions are satisfied. And then 2, so subsection 2, the first condition is the defendant falls within any of the following paragraphs. And one of them, little a, is he's convicted of an offence before the Crown Court. And then subsection 3, the second condition is that the prosecutor asks the court to proceed or the court believes it's appropriate to do so. So either the prosecutor says, let's proceed to confiscation, or the judge says, let's do it anyway. And then the court proceeds in a series of stages, A, B, C, etc. And so it goes through this process of deciding criminal lifestyle and the like. And then over the page, subsection 5, if the court decides under 4B or C the defendant has benefited from the conduct, it must decide the recoverable amount. And B, this is where confiscation orders come in, make an order, in brackets a confiscation order, requiring him to pay that amount. Then there's a section which I'm not sure is key to this appeal, section 7, that deals with the recoverable amount. It's equal to the defendant's benefit from the conduct. And then more about benefit and available amount appears. And then I think next materially get to section 10A, which is one of the key provisions, but not the only key provision that we're concerned with today. So, and it's worth going through this carefully, although I'm sure your lordships have read it more than once. So 10A1, where it appears to a court making a confiscation order, so there's a time point coming in here, it's when it makes the confiscation order, that there is property held by the defendant that is likely to be realised or otherwise used to satisfy the order, and a person other than the defendant holds or may hold an interest in the property. So at the point of making the confiscation order, then carrying on, the court may, we suggest words of discretion, and then another phrase which seems to be underscoring that, if it thinks it appropriate to do so. So if ever there was almost sort of belt and braces here, you've got it there. If it thinks it appropriate to do so, determine the extent, and then in brackets, at the time the confiscation order is made. So that seems to be underscoring the wording at the beginning of section or subsection 1 about making a confiscation order. It's the extent at the time the confiscation order is made of the defendant's interest in the property. Now, what does it then say about the mechanism here? It's in subsection 2. The court must not exercise the power conferred by subsection 2 unless it gives to anyone who the court thinks is or may be a person holding an interest in the property a reasonable opportunity to make representations to it. It doesn't talk about intervention, joinder, or anything like that. It just talks about reasonable opportunity. And indeed, you'll see in some other sections we'll come to where somebody has to make representations. It doesn't even use the word reasonable, it just uses opportunity. So anyway, they've got the word reasonable opportunity put in there. And then
What's to be implied? What's to be implied from making representations? What's the difference between being joined and being given the opportunity to make representations?
Well, if you're actually joined, you generally have powers to see what the other parties are saying. You normally, if you're fully a party to a case, then you have all the rights and obligations that another party would have. I mean, I'll come to this a little later, but in the Crown Court, there is a file, I've forgotten the subsection, the terminology. I set it out in the supplemental skeleton I sent through. In the order, yes, it's called a DCS, which is a digital case system. And so in the judge's order, which was annexed to my supplemental skeleton, the judge's order seems to have comprised 2 pages. And it says Ms. Ahmet cannot be provided with access to the DCS, digital case system. So that there is a...
I think, just carrying on from that,
Yes.
I think what I'm pursuing is, if, and this may come back at the end later in the submissions,
Yes.
if a person is a party to a decision by a court of competent jurisdiction, then they're bound by that.
Yeah.
In all respects.
Yes.
And it may be capable of creating a proper issue estoppel.
Yes.
Is it necessarily the same if someone is not a party but is allowed to make representations, either in the criminal field or in the civil field?
Well, my lord, I would say that it isn't necessarily the same. You have a different status.
That's why I raise it.
Yes.
I admit it's not something that I thought through, but in the light of the way that at any rate it looks as though your submissions may be going, it may be relevant.
Yes. Well, I mean, this case, the judgment under appeal, was recognised presumably as being an important one even before Lord Justice Arnold granted permission, because it appeared in the weekly law reports. And so of course it's the same almost always with your lordship's judgments, that they're looked at very carefully, but in the Crown Court will particularly look at terminology that's used, and so will third parties, because if the Act does give a right to intervene, then you can imagine city firms who, on behalf of third-party banks and that kind of thing, will say, right, well, we have a right to intervene, and that means so-and-so. And so there is a big practical difference. And I agree with your lordship, there are other substantive differences that flow from whether you're a party. Normally, if you intervene, you become a party. You intervene.
Because, forgive me for just pursuing this a second more.
No.
Because I think that the furthest that you can push your case at the moment is that it's certainly not it's not an abuse or excluded in all circumstances, but I would expect you that you may be going to accept that there might be circumstances in which it was abusive for someone to try to manipulate the process either of the Crown Court or of the Civil Court.
Yes.
And in those circumstances, the status that you have might be important, or don't have.
I would agree with that, my lord.
We may need to work that through.
That's why I've set the scene at the beginning of my submissions, that I'm looking at this in the broad sense of how should this work vis-a-vis third-party rights. I can see that, as indeed was submitted by Mr. Evans in a different case to a master, that you can say that the third party who's appearing for some reason, perhaps they've litigated elsewhere, or they should have exercised a right of judicial review, or many other things. You could then say abuse in the wide sense, and your lordships are probably all very familiar with the law of abuse in its many forms. I see this judge, at least on the basis of paragraph 33, whatever else he did, he was deciding this on a policy or a definitive basis that the Act is exclusive. And that's the key issue which I'm addressing. I will, if pressed at the end or at some other point, say that it doesn't follow that anyone who's a third party can muscle in, regardless of the background, because there will be circumstances. There are, well, for example, when we get to the Norris case and we look at arguments about third party claims, it was even clearer back in the Norris day that summary judgment or reverse summary judgment could be deployed to knock out cases that even had no merit on the facts. So somebody might, for example, this isn't this case, but if my client had no arguable case that she had an interest in the house, she was some kind of interloper, then the court would not have to go through all the steps that we're having to consider now, would simply say you've got no evidential basis for your application. So there are many other areas that we could look at, but I'm focusing on the paragraph 33 area. And that's why I flagged up some of those points in the judgment. So I was just turning on to subsection 3, and then there's a conclusiveness provision, but you'll see it's quite narrow. A determination under this section is conclusive in relation to any question as to the extent of the defendant's interest in the property that arises in connection with the realisation of destruction of the property or the transfer of interest of the property with a view to satisfying the compensation order, or any action or proceedings taken for the purposes of any such realisation or transfer. So there is a conclusiveness provision, but it only relates to the extent of the defendant's interest in the property. So the third party, it doesn't follow that in property disputes you've just got two people claiming. You might have, and indeed you would generally find that, for example, a bank's involvement or a bank's interest, if I call it like that, wouldn't be under challenge. But if you said in a typical property which is owned or occupied by two people, there'd be the two people, whether they're brothers or sisters or cohabitees or whatever, and then there'll be at least one other person, there'll be a lender. And so the lender will be a third party, but that third party, those rights and the position between the lender and the normal third party, not the defendant third party, would not need to be litigated, or even if it was the subject of evidence, the conclusiveness provision wouldn't extend to that.
Does this take us very far? I mean, if you said in a case like this, where you have a question as to whether the property is wholly owned by the defendant or somebody else has an interest in it, if you have determined conclusively the extent of the defendant's interest, that's really the end of the story, isn't it?
What meaning that in the present case there are only two, well, there actually is a lender as well, but that there are two individuals who are claiming an interest.
Yes, I mean, in reality, supposing that there were a determination here which was conclusive as to the extent of Mr. Tatum's interest,
Yes.
And it were not possible to go behind that in any civil proceedings, even if the civil proceedings went to a trial, there'd be nothing to fight about, because it would no longer be open to your client to claim an interest in circumstances where it had been conclusively determined that Mr. Tatum owned the lot.
Well, it's an interesting side wind but presumably the conclusiveness would arise in law because Mr. Tatum can't query the extent of his interest, and if my client sought to do so, then she would be perhaps running counter to some abuse principle or something like that, or as issue estoppel, but not as a result of the language of the section.
The realisation of the property can happen in one of two ways. One is the defendant or the person having an interest can themselves sell the property to raise cash, and often sees that, which may need to be released, or they may need to be permitted to do that if there's a restraint order, otherwise restraining they're dealing with, or you put in a receiver and the receiver deals with it. That's
Yeah.
But I'm sure I've seen Mr. Evans in cases where the defendant or a party has in fact realised property, which is then the proceeds of which have gone to reduce the amount outstanding.
Yes. Well, you
So in either of those circumstances, whether it's being sold by or realised by the defendant, the non-defendant third party, or a receiver, this conclusivity provision would apply.
well, a receiver would presumably, like a normal receiver, would be standing in the shoes of the defendant.
Yeah.
So if that was the route chosen, yes, for defendant include defendant or his receiver, assuming it was a receiver in the normal property sense. But there are other different types of receiver even in the Act. I'm perfectly happy to address questions that are focused on the facts of my appeal, but that won't deflect me from.
No, but I think this might be a broader point. I'm not quite sure that I see the limited way in which you say subsection 3 is framed as mattering. The Act is leaving anybody else, if they want to fight about what's left after the extent of the defendant's interest has been determined.
Yeah.
There may be one person relevant, or there may be multiple people relevant, but if it is indeed conclusive as to the extent of the defendant's interest, well, on the face of it, the role of civil proceedings would just be to determine, if necessary, what happened to the rest of the interest.
Yeah. And so it would need to be made clear, perhaps by this court, that you can then have civil proceedings relating to a property that was a subject to POCA, but only to the extent that you've got the Crown Court judge, and then you've got the civil courts used to deal with disputes between more than one third party. But if you take the language of paragraph 33 at its face, then you can't touch the property if it's the subject matter of the Crown Court under POCA. And as we go through, I'm going to try and point out areas where there isn't this coincidence, and you can't say, I would submit, that Parliament has said implicitly everything's over to the Crown Court. And perhaps because I do work in a lot of property work, I can see all kinds of points arising.
I mean, on the face of it, subject to what others may persuade us of, it's very hard to see that there is an exclusive regime applying in every circumstance in relation to property that comes to be caught up in POCA proceedings.
Yeah.
I mean, there might, for example, have been a pre-existing dispute between Mr. Tatum and your client who had fallen out as to their beneficial interests in the property. Along comes the arrest and the restraint order and so on. It's very hard to see how there is an exclusive regime in those circumstances, regardless of anything else. And indeed, the legislation says at that point the court has a discretion as to whether to stay or whatever. I assumed that what the judge had in mind was an exclusive regime in some narrower sense, that where the real debate was between the CPS and an individual, with potential confiscation proceedings in mind, that would be thought to be the exclusive regime.
Yes, well, I although obviously the purpose of an appeal, if you're going to be successful, is normally to criticise the decision of the judge below, I want to make it clear that the judgment that was delivered in this case was quite an impressive feat.
Yes.
Because the judge hears argument in the morning, takes a little while to think about it, and delivers an extempore judgment in the afternoon. So that cuts both ways. It does mean that language that is used that otherwise, that now then gets enshrined in the law report, it carries dangers that he wouldn't have had the opportunity to have all the kind of submissions that you're hearing today to show that there is more than a gloss that needs to be placed upon the words he used.
Yeah.
So we were on subsection 3, and then subsection 4. Subsection 3 is subject to section 58(8)(b).
51(8)(b).
51(8)(b), which is page 60 on the bundle. I will come to, so I'm not keen to jump around too much. I'll flag that up. And then, as you know, if you look in under the heading textual amendments, section 10A was inserted by the Serious Crime Act 2015, and we will see at the end of going through this Act, I will take you to a note to Section 10A that both my learned friend and I both rely on for different purposes or different parts of, because you can use it as a secondary aid to construction. Now, carrying on then with the...
If the words are ambiguous.
Yes.
I mean, isn't that right? One looks at secondary guidance if there's some debate, but otherwise it's the words of the statute that matter.
I would accept that, yes. Just in case anyone said why I was using the phrase secondary, I've even brought along a decision of the Supreme Court dealing with how you apply those things. So anyway, we probably don't need to worry about that. So then there's some sections dealing with interest on sums, effect on other powers. So I wasn't going to look at those. And I then go on to page 15 of the bundle, which is section 14, headed postponement. Now the court may, so this is section 1A, the court may proceed under section 6 before it sentences the defendant for the offence, or if the offence is concerned, or postpone proceedings for a specified period. Period of postponement may be extended. A period of postponement, including one as extended, mustn't end after the permitted period ends. And then subsection 3 doesn't apply if there are exceptional circumstances. And what is this permitted period? The permitted period is the period of 2 years, starting with the date of conviction. So if I am this third party and I have to wait until the criminal process is concluded, but the confiscation proceedings, which are the ones to which we saw section 10A reliance, the making of the confiscation order, we can't assume that confiscation is going to happen at the same day of sentencing. There's a gap in time, or a period of time, which is 2 years, although even the 2 years isn't a maximum, because it doesn't apply in exceptional circumstances.
And there's plenty of authority which identifies exceptional circumstances, and certainly in my experience, a lot of POCAs are not determined, and in big cases anyway, until more than 2 years after conviction.
Yeah. Well, I will very gratefully bow to your lordship's judicial knowledge of POCA in practice, because I confess I don't really have any. What I can do is look at the Act, and when you look at subsection 7, a postponement or extension may be made on application by the defendant, on application by the prosecutor, by the court of its own motion, but at least not expressly listed there is any application by a third party. In other words, somebody who falls within the language of section 10A. So if I am this third party who's having to wait to see what happens in the Crown Court, it's not good enough me just waiting to see whether the chap's convicted or not. If he is convicted, then there's a time lapse, which we hear can be a long time before POCA comes in. And I might want to make representations. I'm not formally permitted to do so. So unless I can write to the court, or my lawyers can write to the court, and invite the court of its own motion to do something because of the loss or the problem that I'm facing, then I'm having to wait, because I'm not allowed to bring any civil proceedings if the judge is right.
I mean, is this slightly the wrong way round, in the sense that on your thesis, the third party wouldn't want the postponement or extension, but would rather potentially want to make representations as to the postponement or extension?
Yes, that's right. So either third party would want it to be faster rather than the process. These are the maximum periods, but I then am told that the prosecution and the defence, for their own purposes, have decided to leave it for, 23 months or something. And I'm rather annoyed about that, but what do I do? Then there's some provisions about the effect of postponement in section 15, information in 16, and the like. Can I go on to 18A on page 21? which, and some of these provisions I'm taking you to are really the sort of provisions I imagine my learned friend would go to, so I'm trying to be even-handed. This section applies if the court is considering whether to make a determination under section 10A of the extent of the defendant's interest in the property, or is deciding what determination to make if the court has decided to make a determination. Interested person means a person other than the defendant who the court thinks is or may be a person holding an interest in the property. For the purpose of obtaining information to help it in carrying out its functions under section 10A, the court may, at any time, order an interested person to give it information specified in the order. So this is obviously helpful from the point of view of the judge receiving information. It's the sort of provision that you probably wouldn't need if you could be joined formally to the process, because then you would assume that as a full party, all the powers for the making of orders would apply to you. But anyway, this is an adjunct and was also introduced, if you look on page 22, under textual amendments at the end. It was also introduced by the 2015 Act. Now, we then turn the page and we go to page 24 and we come to appeals. And it's appeal by prosecutor. Now it's etc. And the first three subsections do not seem to be material because this is the prosecutor type appeals. But subsection 4 and later are material. An appeal lies to the Court of Appeal against a determination under section 10A of the extent of the defendant's interest in property. And then 5, an appeal under subsection 4 lies at the instance of the prosecutor, or B, a person who the Court of Appeal thinks is. It's quite a slightly unusual language that the Court of Appeal thinks, but the Court thinks is, or maybe a person holding an interest in the property if subsection 6 or 7 applies. So you can appeal if you first of all satisfy 5B, and then you have to go on to 6 or 7. 6, this subsection applies if the person was not given a reasonable opportunity to make representations when the determination was made. So in other words, the process has gone wrong because section 10A tells us that's what should have happened, but wasn't given a reasonable opportunity. So this isn't about not taking it up, this is you weren't given it. And 7, the subsection applies if it appears to the Court of Appeal to be arguable that giving effect to the determination would result in a serious risk of injustice to the person. So you've got a rather different sort of language in relation to your appeal if you're this interested person, because we'll assume that you were given a reasonable opportunity to make representations and you made the representations and you now want to appeal. And so you have to, it has to be arguable to the Court of Appeal, not that you've got the normal civil test for an appeal, but a serious risk of injustice to the person.
Well, it's more limited than that, isn't it? Because it's giving effect to the determination would result in a serious risk of injustice.
Yes, yes.
So that arguably isn't an appeal against the determination itself, but as to the effect of it.
Yes. Yes.
You know, a mother and 7 children made homeless type thing.
Yes, yes. So anyway, this is obviously a point that I make for myself that is a.
So you say that the judge was wrong when he said, as it were, there was a route of appeal,
yeah,
without at least qualifying it by reference to the fact that you say the route of appeal is much more limited.
That's right.
So suppose, for the sake of argument, it were determined in the Crown Court that Mr. Tatum had a 55% share in this property, when your case is that his share is only a 50%
Yeah.
share. Are you allowed to appeal on the basis that depriving you of the 5% exposes you to serious risk of injustice, or is 5% too small?
Well, as it happens, the relevant person to ask in those circumstances, or persons, are the Court of Appeal, because it appears to the Court of Appeal. So I can just sort of bat it back and say,
But at any rate, you say, well, in an ordinary civil case, it's straightforward. You just ask whether there is
yes,
a real prospect of success in establishing the 50% rather than the 55%.
yes,
This introduces an extra criterion.
yes. And then if you satisfy that you get your appeal underway, then at section 32, 2A, then on your appeal, the Court of Appeal may confirm the determination or make such order as it believes is appropriate. So if you can satisfy the hurdle, then you get in front of the court, and the Court of Appeal can make such order as it believes is appropriate. And then, I imagine would happen very often, but section 33, you can even go off to the Supreme Court. Then going on a bit further, we then go on to page 35, the restraint order, because this is often how the process starts. And this is important to see when this bar that the judge was creating comes into operation. So what are the conditions for the exercise of the restraint order powers? 1, the Crown Court may exercise the powers conferred by section 41 if any of the following conditions is satisfied.
Sorry, where are you?
Sorry, page 35, my lord.
Thank you.
Section 40, subsection 1.
Sorry, I went to section 35.
So, subsection 1, any of the following conditions. So we don't have to spend a long time going through all the conditions, because if you look at the first one, subsection 2, the first condition is a criminal investigation has been started in England and Wales with regard to an offence. So the time at which a restraint order can be made is really early on in the process. In fact, criminal investigation has been started, and there are reasonable grounds to suspect that the alleged offender has benefited from his criminal conduct. Now, you've got other things, proceedings have started, so you've got other conditions that are later in time, but that's not material for the purposes of my submission, because here we've got the criminal investigation has started. So, and I'm not saying it's wrong that you can't have a restraint order at an early stage, as you would in a civil proceedings. You have it at a very early stage, and indeed, if you don't step in an early stage, the judge might say, "Why are you here now? Why didn't you step up earlier on?" So,
But does B mean there are reasonable grounds to suspect the alleged offender has benefited from his criminal conduct in relation to the offence in respect of which a criminal investigation has just been started? It's typical sort of. But the thing is, POCA is such a demanding act anyway
yes,
that one shouldn't even raise an eyebrow at that. But that is quite eyebrow raising. It means that, if that's right, it means that the police start an investigation into an offence, an alleged offence today.
yes,
They haven't. That's all they've done. Their target is someone who they think may be an offender. But they're not in a position to prove it or anything, and they haven't arrested or anything like that. All they would need to show is that there are reasonable grounds to suspect A, the commission of an offence, and B, that the person concerned has benefited from it.
yeah,
His criminal conduct.
yes.
That's what it means.
Well, I note your lordship's question. I'm loath to proffer a reasoned answer because I don't know.
Well, Mr. Evans will have a view.
I'm sure. So that's the condition for the exercise of the power restraint order, and then the restraint orders themselves, page 38, that's section 41. If any condition set out in section 40 is satisfied, the Crown Court may make an order, a restraint order, prohibiting any specified person from dealing with any realisable property held by him. And you may know, I didn't know, because I spent some time looking for a definition of specified person, and there doesn't seem to be one. It seems to be my junior. I give credit to my junior for this, if it's due. Yes, it is in the Stanford case, which we've got later on in the bundle, at page 322 in paragraph 163, Lord Justice Hughes says, letter B, the specified person need not be and often is not an actual or potential defendant. And I may be wrong, but we haven't found a definition of specified person. Anyway, prohibited any specified person from dealing with any reasonable property held by him. And a restraint order may provide it applies to all realisable property held by the specified person, whether or not it's described in the order, and to realisable property transferred to the specified person. So the restraint order potentially can be wide in its effect.
And any specified, you wouldn't necessarily expect a definition, would you? Because any specified person is any person specified in the order.
Yes. Well,
I mean, it makes your point that it's incredibly wide, but that's what that is what it's referring to, isn't it?
seems to be. Yeah.
I mean, the limitation must be to do with realisable property, presumably.
Yes. Yes.
I can't remember whether I've seen a definition of realisable property. I'm sure I have.
No, there is. Wait a minute, I've got a flag for it. Yes, it's page 94 of this bundle, section 83. Realisable property is any free property held by the defendant or any free property held by the recipient of a tainted gift.
So in that sense, the specified person doesn't matter so much because it is tied to property held by the defendant or property held by the recipient of a tainted gift.
Yeah. Well, that's right. I was just, I'm an old-fashioned guy. If I see a phrase, I normally like to look for a definition. So and then there's we need to look at across the page at page 39. So going back to section 41, subsection 7. The court may make such order as it believes is appropriate for the purpose of ensuring the restraint order is effective. You'll see how that creeps in a little bit later. And then the next subsection, the next section is section 42 on page 44. This deals with applications, discharge and variation. So 1, a restraint order may be made only on an application by an applicant falling within subsection 2 and may be made on an ex parte application for judge in chambers. And these applicants fall within this subsection, the prosecutor or a financial investigator. So those are the people who can ask for it. And then 3, this is important because Mr. Evans is telling us, or told the judge below and probably will still say, don't worry third party, you know, you've got these powers to come back and apply for variations. An application to discharge or vary a restraint order or an order under section 41(7, that's why I read you that, may be made to the Crown Court by the person who applied for the order or any person affected by the order. But what we're into, of course, the territory we're in here is effectively Morava type relief. We're into restraint. So we're not talking about resolution of property interests in the normal way. If you're a third party, you're not going to be able to insist on your Crown Court judge having a determination of the property interests. It will presumably be dealt with on the usual criteria about the purpose behind the restraint order and the like. So short of you coming up with slam dunk killer evidence that it's got nothing to do with the defendant, you're not going to be able to resolve the thing. Or sometimes, as indeed did happen in this case, you want a variation because you want some money from an account to pay off a mortgage. And everyone would probably agree that because you don't want the property to be repossessed by the lender. So those are applications. Then, if we go on to a type of receiver, we go on to page 54. This is management receivers. 48(2). The Crown Court may by order appoint a receiver in respect of any realisable property to which the restraint order applies. And then you also have enforcement receivers. They're at section 50 on page 58. But this is further down the road. This section applies if a confiscation order is made, it is not satisfied, and it is not subject to appeal. And then on the application of the prosecutor, the Crown Court may by order appoint a receiver in respect of realisable property. So this is further down the road. If we just look, because there are some provisions about third parties here. So if we look at section 51, powers, if the court appoints a receiver under section 50, it may act under this section on the application of the prosecutor. And then 2, the court may by order confer on the receiver the following powers in relation to realisable property. And amongst the list of the powers, little c, is the power to realise the property in such manner as the court may specify. And then subsection 6, the court may order a person holding an interest in realisable property to make to the receiver such payment as the court specifies in respect of a beneficial interest held by the defendant or the recipient of a tainted gift, and may on the payment being made by order transfer, grant or extinguish any interest in the property. So things can happen in relation to the realisable property. And then 8, the court must not confer the power mentioned in subsections, and that includes little c, which I read, which was realising the property, or exercise the power conferred by subsection 6, unless it gives persons giving interest in the property a reasonable opportunity to make representations to it. And then dropping down to 8b, so this was the provision that we saw, I said we'd come back to rather later, section 8b, representations that a person's entitled to make by virtue of subsection 8 do not include representations that are inconsistent with a determination made under section 10a, unless the person was not given a reasonable opportunity to make representations when the determination was made and has not appealed against the determination, or b, it appears to the court, we're now just the court, not just the Court of Appeal, that there would be a serious risk of injustice to the person if the court was bound by the determination. So we've got, here we're not into appeals, but we're into right to make representations, but the right is fettered at 8bb.
And fettered in the same way.
In the same way.
Yeah.
Now we then move on to page 63, the restraint orders and certain restrictions relating to them. And Maloney Friend and I both try and gain some assistance from this. I say this seems to be a recognition that you can have civil proceedings running along. So if we look at
this is concerned with restraint orders, which we've just left, as it were.
Yeah.
Those are sections 40, 41, 42, 43 that you showed us.
Yeah.
And it shows the appeal to the Court of Appeal or the Supreme Court. And then it goes on to, the Act goes on to deal with something else.
Yeah.
And then we come back to, in this particular section, restraint orders.
Yes.
Anyway, there it is. So these sections, 58 onwards, are called restrictions.
Yeah.
But you say these are the restrictions, so-called dealing with restraint orders at 58.
Well, they're recognising proceedings elsewhere. So the subsection 1 talks about they apply if a court makes a restraint order, and these are not, I think, material to my submissions. It's to do with rights of forfeiture and that kind of thing. I want to pick it up at 5, subsection 5. If a court in which proceedings are pending in respect of any property is satisfied that a restraint order has been applied for or made in respect of the property, the court may either stay the proceedings or allow them to continue on such terms as it thinks fit. So, the court in which proceedings are pending in respect of any property, is that, as I would suggest, civil proceedings? I mean, I should have well, and then if we read on, and I'll make some submissions, subsection 6, before exercising any power conferred by subsection 5, the court must give an opportunity to be heard to the applicant for the restraint order and any receiver appointed in respect of the property under section 48 or 50. And so this isn't talking about the third party, but this is talking about the applicant for the restraint order or the receiver. Although strangely, it's
But the
just
working
an
assumption
opportunity.
is that the third parties are engaged in the proceedings. So you've got the third. You've got the parties to the proceedings in respect to the property, and the people who need to be given an opportunity
Yes,
are the applicant for the restraint order or the receiver.
yes. I mean, there's a little side point here. Why it just says opportunity and not reasonable opportunity, I don't know. But I suppose if someone said, do you mean reasonable opportunity? But it's strange they haven't put it in. But the bigger point.
The real point is, if you're right about 5,
Yes.
that if a court in which proceedings are pending in respect of any property, i.e. in this instance, your claim,
Yeah.
then you're going to be heard anyway. So
Yes,
you wouldn't need to be referred to in 6 because you're already in 5.
Worried about 6. So but what I'm saying is, in proceedings are pending. So presumably civil proceedings. It says proceedings are pending. It has been applied for or made. The court may either stay the proceedings. So what is this court that they're talking about? The court may either stay the proceedings or allow them to continue on such terms as it thinks fit.
Well, it's not the capital C Crown capital C Court, because that's referred to with capitals in,
Earlier on.
for example, subsection 3.
Yes. So I suggest that subsection 5, which isn't that easy to construe, contemplates parallel proceedings.
I may be being very slow here. But am I wrong just to say the one thing that paragraph 5 cannot be referring to when it refers to proceedings pending is POCA proceedings?
No, I agree.
And I think from Mr. Evans' reaction to my rather banal point that may be common ground. And if it's not POCA proceedings, it's going to be civil proceedings.
Yes, I would think so.
Well, until someone comes up with an alternative.
Yes.
I mean, a situation that plainly this bites on is where you do indeed have, say, proceedings between Mr. Tatum and your client as to their shares in the property. Then along comes the CPS, says we're arresting you and we'd like a restraint order. So there are pre-existing civil proceedings at the time when the restraint order is applied for, and also when the restraint order is made.
Yes.
So that may be possibly the prime situation that Parliament had in mind. Your case is obviously not limited to that situation. It's limited to any situation where it extends to any situation where a restraint order has been made or applied for, and there are then civil proceedings.
Yeah. I mean, the problem I have with the judge's bold statement in paragraph 33 is that it's so black and white. It doesn't afford the flexibility that we would normally have with case management. And you will see in some of the dicta that we will look at a little later that there are references to case management, and it's of course great for the CPS. I can see why they like this result, because then they can say, off you go. You whatever you're doing elsewhere, these civil proceedings, you can't litigate there. You must wait for the Crown Court and see what happens there. But that doesn't fit in very well with subsection 5, and there are all kinds of temporal issues. You can have civil proceedings, to take your lordship's example, that have been on foot for several years. Equally, and this becomes obviously slightly trickier from someone in my client's point of view, there is a restraint order catching a property, but you have arguments that you want to advance about the interest you have in that property, You don't want to wait to see what happens in the Crown Court with a conviction or otherwise, or the confiscation proceedings. You would like a ruling, and so they come to innocent guy like me, who's a property lawyer, and say, what do you do? Well, what you do is you issue proceedings for a declaration as to your interest, the standard sort of proceedings that you would get. And of course, at that point, we haven't got any conviction, we've got a restraint order. And yet, it's certainly going to be Mr. Evans' submission, I understood it to be a submission lower down, that even though we haven't got to the stage of a conviction, the very fact that we've got the restraint order, that's it.
You don't even need an arrest.
No. As you saw.
My understanding, which I raised to you a minute ago, is correct.
Because it's enough that the criminal investigation has started.
Yeah.
Just to be clear, my understanding is that it is your case that Section 58(5) applies in our circumstances. Is that right, or are you adopting
Yes.
a more limited construction?
No, I would accept that the proceedings are pending in respect of a property, and so the court, that means the High Court, may stay the proceedings or allow them to continue.
And so, I mean, you're not saying what the outcome would have been, but on your case, it would have been open to the CPS to apply for the civil proceedings to be stayed.
Yeah. And they're not for decision, I suggest today, because it's very nuanced. But down the road, if you're with me and you decide that there isn't this exclusiveness with the Crown Court and that it's a matter for the High Court, then there might be another stage to litigation like this in which it's decided whether the civil proceeding should be stayed or not. And it's a multifactorial type of decision. So there's many things that would come into play. I'm not here to advance submissions.
But we need to think about it. What? Because a flow that could happen is you have a restraint order when proceedings are already on foot in another court. The other court could, on the facts of the particular case, decide to stay the civil proceedings.
Yeah.
Presumably for good reason on your submission.
Yeah.
POCA proceedings go on and a properly constituted POCA hearing takes place, and the Crown Court decides, having given reasonable opportunity and all that sort of stuff, that your client has no interest or 10% interest or whatever.
Yeah.
You then have a ruling on the issue by a court which is undoubtedly a court of competent jurisdiction. Now, in those circumstances, it seems to me, at any rate, that if you get to that point, the civil proceedings are in trouble, because if you then just simply undo the stay, you're immediately allowing for the possibility of a collateral attack on the decision of a court of competent jurisdiction.
Yeah.
So even if we're with you on the general thesis that there's no blanket exclusion of other proceedings, as it seems to me at the moment, one has to acknowledge that there may be circumstances, of which the one that I've just outlined to you is one,
Yeah.
where it could become abusive for the other proceedings to be continued. And if to be continued, there could be circumstances in which it was abusive to bring them in the first place.
Yes, my submissions, I think I'd said, and I would say again, that I'm not ruling out all the general law that there is about abuse of process, because it covers so many. It's one of these things, you try and pin down what is abuse. It's rather like pinning down what is estoppel. You can come up with a series of definitions. The stay thought, if I can just pursue that for a moment, if there's an application made in the civil court for a stay, then obviously the merits on the stay are investigated. If a stay is granted, but someone in my client's position, the third party, is unhappy with it, then you're in the civil realm, so at least you have a right of appeal. And it's not a fettered right of appeal in the way that some of these things are. It would be a normal civil right of appeal had the master or the judge who made the decision had done so taking into account all the appropriate factors.
I mean, to be fair, that might not help you all that much because it would be an evaluative or case management type decision, and they're not easy to appeal. But
Yes.
yeah.
Yes. No, but at least you have a right of appeal that is a normal civil right of appeal.
Yes.
So I was into that. So this is restraint orders, and then if you go to the next section, so that's section 58, section 59, there's provisions about enforcement. As far as I can see, this section more or less duplicates the section 58. You've got some provisions about tenancies and the like, and then subsection 5, if a court in which proceedings are pending in respect of any property is satisfied, an order under section 50 appointing a receiver has been applied for or made, may either stay the proceedings or allow them to continue. And then you've got subsection 6 in comparable terms. So they go together. And section 50 is the enforcement receiver, yes. Then we've got through most of the relevant portions. That's just the section 63 on page 72. There's a general provision for people applying to the Crown Court to vary or discharge an order. The receiver or person who applied for it, the person affected by the order. And then general rights of appeal, that's section 65 on page 78. And then section 69 on page 84, powers of the court. So subsection 1, this section applies to the powers conferred on a court by sections 41 to 59, so that's restraint orders and receivers and the like. And the powers, subsection 2, little b, must be exercised in a case where a confiscation order has not been made with a view to securing there is no diminution in the value of realisable property. So if you don't have a confiscation order, you've got to make sure that the third party is not affected.
Sorry, are you leaving this provision?
Yes.
Now, I think Mr. Evans says that if you take, say, the power to stay under section 58(5), that has to be exercised with a view to what you get in 69(2). And is that right?
If that's the same as the comment I made just now, then I agree, which is that 69(2)(a) is you have to make sure there's no where there's no confiscation order, then it wouldn't be right to interfere with a third party. If he's submitting differently, then I would disagree.
So just to be absolutely clear, the 69(1) says it applies to the powers conferred on the court by sections 41 to 59. Well, that obviously includes section 58. 58(5) says a court may stay the proceedings. 69(2) says the powers, seemingly the power conferred by section 58(5), must be exercised with a view to the value for the time being of realisable property being made available for satisfying any confiscation order. So does that mean that when you're exercising your power under 58(5), you have to do so with a view to the value for the time being of realisable property being made available for satisfying a confiscation order?
Subject to subsection 3.
Yes, I was going to.
Yes, I see.
Yes, 3A, yes. So 69.2 is wide, but then you've got a carve out.
Yes. So maybe it doesn't take you any further because you have to exercise your power under 58.5 with a view to both objectives, and perhaps they don't really help you very much.
Yeah, well, and although we are looking at all these provisions, of course, we haven't got a case yet where you've got a 58.5 ruling.
No.
Then there's a definition of tainted gift at page 89, section 77. It's essentially, there's a definition at 78.1. It's where you transfer, the value is significantly less than the value of the property at the time of the transfer. So that's what you'd expect. And then I took you to section 83, realisable property already. And I think for these purposes, that's what I was going to be taking you through in the Act. I did say that when I'd gone through the Act, I would then be taking you to the note, which has been slotted in this bundle right at the back. So you have to go to tab 19, page 464. I've got various portions of this note, which is not very long. It's only just about a page long. Unless you'd like me to read it out loud, I'm inclined to suggest that your lordships might want to read it to yourselves.
The whole thing,
The whole thing, yes. But
because there's redlined paragraph.
yes, no. Well, the
Is
red
this
line.
the explanatory note that goes with the Act?
It goes with section 10A. So it's the whole of the note that is material, because the Serious Crime Act introduced section 10A. So this is all for 10A.
Yeah. We'll do that. You haven't heard any message, have you? Thank you.
Does the last paragraph mean anything more than pocket cases should be listed in front of judges who are competent to deal with it?
Well, it's certainly not suggesting that you only deal with cases with property interest in the Crown Court, because it says the Crown Court will only make such determinations in relatively straightforward cases. So it isn't just dealing with expertise in the Crown Court, it's dealing with the Crown Court as a whole. Now, the CPS are very keen that the Crown Court judge be given a very wide ambit in relation to this. I'm not speaking on behalf of third parties, I don't share his enthusiasm. But I'm not going so far as to throw any imputations about the Crown Court judges generally. It's just this is simply indicating what the drafters thought. Now, I'm very grateful for your lordships taking that. You can probably see that if I just cherry picked a few things and my learned friend, then you finish up reading the whole note anyway. This way you get an overall view of what's happening. And the point, paragraph 19, is emphasising that the question of the 10A only comes in on the making of a confiscation order. And as I've already said, that can be a long way down the road. So, and the note would simply encourage judges to simply make no decision. So if you're a third party and you apply to the Crown Court judge at any earlier stage, he could anyway say, well, I'm not making a confiscation order yet, so what are you bothering me about? So the exercise in the Crown Court is very time specific. You go through this process. Is there a conviction? Then are we going to have a confiscation proceedings? And then are we going to have a confiscation order? That's near the end of the process. So that's the Act, and that's the note on Section 10A. The second of the three points I was going to be addressing is the exclusive jurisdiction principle, but not in pocket type cases, and actually look at the principle more generally. The principle, the exclusive jurisdiction principle, has its origins in the 19th century, or it did as far as I could see. I tracked some of the early cases and I listed them in my permission skeleton, paragraphs 24 to 33. As far as I can see, Mr. Evans doesn't dissent from anything I said there about the background. And in the circumstances, I was going to only refer to two cases under this category. One is AutoLogic, and the second is this recent case, very recent case, of BT and IRC. So if we can look in our authorities bundle at tab 9, and we go, so that's page 182. If I can just make this preliminary observation about AutoLogic, it's one of the tax cases. There are many of them. Tax is, of course, a creature of statute with a detailed code, so it's not surprising the courts are keen not to allow litigants to depart from the code. It talks about, you get taxed in these circumstances. If you challenge it, you go through this process. Real property is not a creature of statute, fundamentally, and so the same expectation doesn't apply as you get in AutoLogic. But nonetheless, we must look at the reasoning. There's the head note, which is flagged. It's quite a complicated case, as so many of these are, so I'm not going to attempt to wrestle with the tax implications. What's interesting is to look at the submissions of the revenue in the case at page 185. So you had Mr. Plender and his junior for the revenue, top of page 185. The issues in the appeal are whether the High Court has jurisdiction to hear the claim for restitution for monies paid under the UK tax regime, and if so, whether the High Court should hear the claim. And then there's a paragraph that's useful. The decided cases establish that where a statute confers a right and specifies a remedy for its infringement, it's not open to a claimant to seek damages by way of the High Court. The general principle is the existence of a statutory scheme containing its own system of remedies excludes the ordinary remedies available in a court of law. By conferring a statutory remedy, the legislature has implied that no other court has jurisdiction. Then there's a whole list of cases, including Barraclough and Brown, which is one of the early cases at the end of the 19th century. So that was the submission that was made, and broadly, that's the submission that was accepted in the principal judgment of Lord Nichols. The relevant paragraph, actually I should probably say, just look at paragraph 1 on page 186, just where he introduces it. My lords, on these appeals, the question before the House is procedurally, should the principal substantive issues raised by the 6 claimant groups of companies be heard and decided by the High Court or by the special commissioners? Resolution is difficult partly because of the variety of claims being advanced, and there's a huge number of companies involved. And then if you go back to 189, paragraph 11, in resolving the question of jurisdiction, the starting point is to note two basic principles. The first concerns the exclusive nature of the Appeal Commissioner's jurisdiction to decide certain types of disputes arising in the administration of the country's tax system. The present disputes concern group relief. And then dropping down a matter, to what matters is whichever system is applicable, an assessment which disallows a group relief claim can't be altered except in accordance with the express provisions of the tax legislation. And then there's a bit more about the legislation. And then paragraph 12, clearly the purpose intended to be achieved by this elaborate, long-established statutory scheme would be defeated if it was open to a taxpayer to leave undisturbed an assessment with which he is dissatisfied and adopt the expedients of applying to the High Court for a declaration of how much tax he owes, and if he's already paid the tax, an order for repayment of the amount he claims was wrongly assessed. In substance, though not in form, it will be an appeal against the assessment. And then, so that's the background to it, and then over the page, you've got paragraph 13. I question whether in this straightforward type of case, the court has any real discretion. Rather, the conclusion the proceedings are an abuse follows automatically once the court satisfied the taxpayer's court claim is an indirect way of seeking to achieve the same result as it would be open to the taxpayer to achieve directly by appealing to the appeal commissioners. Taxpayer must use the remedies provided by the tax legislation. And then there's a reference to two cases of which Barraclough is one of the two. I'm almost tempted to say, well, isn't this all rather obvious? But it took a case to go to the House of Lords before you got that case decided.
What may not be quite so obvious is this a matter simply of statutory interpretation, or is it something beyond that? Lord Nichols questions whether there's any real discretion. Well, if the statutory regime prescribed by Parliament is such that, as a matter of statute, anything else is excluded,
Yeah.
then you'd think, well, you don't even question it. Plainly, it's impossible. I'm not quite sure that fits with what follows. So, for example, where Lord Nichols endorses Mr. Justice Robert Walker and Glaxo, that looks more sort of touchy-feely rather than a statutory exclusive regime.
Yes. Well, you can of course have the statute creating the remedies, which itself specifically says, and the only way you'll challenge this will be such and such. And sometimes you get that, and sometimes you don't. But in this case, they're saying, I mean, the ratio of the case is it's all left to the tax. You can't go outside the tax.
I absolutely follow that. But there may be two slightly different ways of getting to that result. One is, look, Parliament, by laying down this regime, has impliedly excluded any other possibility.
Yeah.
And the other is, Parliament has laid down a regime, and then on a sort of touchy-feely basis, it's an abuse to try to use a different regime.
Yes, I have my doubts about the touchy-feely. I mean, that's why I was looking for, because these points do seem to crop up with some regularity, and that's why when I was doing some further researches, obviously post the grant of permission in this case, I came up with the BT case.
Yes.
And so if I can take you to that, because that seems to be at appellate level a statement of how one approaches this type of case. So it's page 424 near the back of the bundle. It is another tax case, it's a VAT case. If you look above the head note in the little italic section, it's VAT, refund of tax, bad debts. The taxpayer was issuing a claim for restitution against the revenue for unjust enrichment, and the revenue applied to strike out the claim, whether the statutory scheme operated to exclude common law claims, and whether it was arguable that there was unjust enrichment. And then there was some various EEC legislation that was referred to. Now, then if we go into the if you then look at the list of cases on page 427, you'll see that amongst the cases referred to, the fourth one down is the loss relief claim litigation order, but it's sub-non Autologic Holdings. So that's one of the cases they looked at. And then if we get the principal judgment, indeed it was the judgment with which the other two judges simply agreed, yes, Lord Justice Warby and Lord Justice Newey simply agreed, was Lady Justice Falk. Then if we look at the issues on page 433, paragraph 24, issue 1, whether Mr. Justice Miles was wrong to decide that Parliament had intended in enacting the old scheme to oust other forms of claim, such that the claim in respect of the main period should be struck out. It's called the exclusive remedy issue. And then if you turn over the page, you'll see that in fact there's about 3 and a bit pages that have been sidelined. That's because there's quite a sort of thoroughgoing analysis by the court. If you look at 27, a number of authorities have considered whether a legislative scheme is intended to exist alongside common law remedies or is intended to be exhaustive and exclude them. Some are tax cases and some concern other areas. And then there's a long list of where they can extend to. And then 28, Mr. Justice Miles relied on the following summary by Lord Justice Higginbottom of the principles to be relied in Southern Gas. And then there's a quotation where he says, it's unnecessary to quote at length from the cases to which I've already referred. The following propositions can be drawn from them. And then there's a series of propositions, in fact 4 propositions that are then set out. If you look at proposition 2 at little d, where the intention is not express, which is our case and it's often the case, the threshold for inferring ouster of common law rights is high. It's not helpful to approach the question on the basis there's a presumption against ouster, nor before common law rights are displaced as ouster have to be a necessary implication. It cannot exist with the statutory regime. So I obviously latch on to the first sentence, which is the threshold for inferring ouster of common law rights is high. And then at little 3, whether common law remedies are ousted is dependent upon the true construction of the particular statutory provisions. And that is obviously why I've taken you through POCA at a little length. And then I'm not seeking to cut out all of this, but although I invited you to read the note, that was 1 page. This is about 3.5 pages. I'm not saying you don't read it all, but then if you go to the end of the sidelined portion and you get to paragraph 35, the judge says, drawing some threads together, and then if you look at threads little b and little c, bearing in mind that remedies may be excluded even if they haven't yet been established, I find it more helpful to frame the inquiry as being whether Parliament intended the statutory provision in question to provide the exclusive or sole remedy, rather than asking whether an alternative remedy was intended to be ousted. So you then ask, was that the intention in relation to POCA and the Crown Court? And then C, put very shortly, the question can be formulated as whether Parliament intended the statutory remedy to be exclusive or whether it intended the remedy to coexist with any other remedy. So those are...
You're leaving this case.
I'm going to leave that case.
I don't know if you can provide an answer to this. You point out that Autologic, well, I think it was not only cited, but it's referred to somewhere in the judgment.
Yes.
But it doesn't seem to be referred to in this section. Has anybody worked out where it is referred to?
I think it's... I think it's the case comes in under a different name. Let me just find. I think it's
probably
claimants under loss
yes.
relief.
It's described under a different name, isn't it?
Yes, it's described
Loss relief group litigation
as
order.
2005, 2006. It's not in the list at paragraph 27.
No, it must be somewhere in this judgment, otherwise it wouldn't feature where it's shown earlier.
Yes. All right. Can I just ask my junior
Yes.
to make that little search there, and and then I'll come back to that.
Yeah.
What I was going to do at this point, having cited those two cases, is then going to make three very short submissions. The first is, self-evidently, there is nothing express in POCA to exclude civil law rights. And then the second point is flipping it over. We say it's implicit within POCA that civil rights remain. And that's why, for example, section 58.5 and 59.5 are material.
66, by the way, Mark.
Oh, Malone and Friends, let me just find it.
I overheard that. That was paragraph 66, and indeed,
Yes.
also logic is cited in paragraph 66.
Yes.
Yes, I see.
I've made two submissions. The third submission is section 10A is couched in discretionary terms. Double discretionary terms, I might say, but so that's the end of my part two. The end of I now come to my part three, which is my remaining chunk. This is my heading is jurisprudence re POCA and its predecessor, and I say taken as a whole, POCA does not exclude access to the civil courts, and if it did, then the Court of Appeal would have said so, and they've said things to the contrary effect. And what I'm planning on doing, I apologise if I'm going too fast, is I'm going to canter through the cases chronologically, trying to explain in a sentence or two what the issues were and taking you to what seem to be the key portions. So the first case is Norris, which itself had to consider, as we'll see, Hunter, and I will take into account that. Now, the jumping ahead, you'll see that the Supreme Court decision in Aquila shows that the principle in Norris still lives on. So just flagging up, don't forget we come to Aquila, although of course the legislation has changed. So in Norris, page 166, the head note, I'm not going to read the background. The background facts were quite important, but I set them all out in paragraph 36 of my skeleton. And so you know that the wife gave evidence and was not believed, and so you had the Customs and Excise wanting to say that it was an abuse for her to be seeking a claim. And what we need to do is look at the Customs and Excise argument as it developed. Page 176, paragraph 22. So the Customs and Excise had a construction argument that they gave up on. So if you look at 22, in the Court of Appeal, Customs didn't seek to uphold the decisions of Mr. Justice Buxton and Latham, insofar as they said the High Court had no jurisdiction in any circumstances to reopen the findings of the Crown Court on the application of a third party. The Court of Appeal considered this concession was rightly made, and the judgment of Mr. Justice Buxton couldn't be supported. I agree with the Court of Appeal. The argument on the construction of the Act having been abandoned, the Customs and Excise based their case on a different submission, that there was a spectrum of possible situations, and the relevant consideration was abuse of process. Counsel submitted that Mrs. Norris fell on the wrong side of the line. Her interests were identical to the defendant at the hearing in the Crown Court, where the wife had the opportunity to give her evidence and have her case argued by counsel. The fact she was not formally a party to the proceedings or represented is unimportant. And the Customs relied on the Hunter case, and Lord Justice Tuckey accepted the argument. He considered that if the third party had a fair opportunity to put his or her case at the earlier hearing, nothing unfair in preventing him or her relitigating an issue which had been decided in proceedings to which he or she was not a party. And then there's quite a detailed explanation of why the House of Lords doesn't agree with the Court of Appeal in relation to this. And they say at 23, or this is Lord Hobhouse, "My Lords, the reasoning and decision of the Court of Appeal depend on the view which they took of the breadth of the principle of abuse of process and their assessment of what had occurred in the Crown Court. Neither can be supported." And then that paragraph goes on. They talk about the criminal jurisdiction and then go over to the top of page 178. Criminal jurisdiction solely concerned with the parties before it, the prosecution and the defendant. In some situations, the Crown Court may also make compensation or restitution orders in favour of third parties. But it is well established that these powers are only to be used where there is no disputed civil law right or similar issue which needs to be determined. If there is such an issue, the proper course for the Crown Court to take is to leave the relevant person interested to pursue his or her civil remedy in the civil courts. And then this sentence, which I've underlined, "The English system of criminal justice does not itself confer any civil jurisdiction on the criminal courts. It takes clear and express provision in a statute to achieve that result." And of course, it'd be that which you'll then have
Sorry,
to...
I'm very sorry, Mr. Warwick. Where are you reading from?
I was reading, it's page 178 of the bundle.
Yeah, I've got that
I'm
page.
reading, if I picked it up at big B in the margin. And it's well established that
Oh, yeah.
these powers, and it's down to the end of, just below C. But if I carried on with the quote, "The 86 Act doesn't contain any such provision, as is already explained. Its clear intention is to preserve the distinction between the respective jurisdictions. The time and place for her to assert her civil law rights was when the Customs and Excise attempted in the High Court to deprive her of her interest." Now, obviously, the Act at that time is not the same Act as we've got now. It's all about this case. What is the Act that we've got now, and what is its scope? And perhaps I should just take you to the end of paragraph 25 on page 179, the final sentence. Mrs. Norris is not misusing the procedure of the High Court. She is making the proper use of the civil jurisdiction of the High Court to protect her proprietary rights as the 86 Act contemplated she should. Oh, and then the one other passage that's sidelined, I see, is over on page 180. This picks up something I said very early on today. Just below letter G on page 180. "Before your lordships, the Customs have urged your lordships to dismiss the appeal, since to fail to uphold the judgment of the Court of Appeal would be to create an inappropriate hindrance in the way of the enforcement of confiscation orders through the civil courts. This is not so. If the third party is seeking to resist enforcement on grounds that be seen to be bound to fail, then there's no reason why enforcement should be held up. If, on the other hand, there's something in the third party's defence in the civil proceedings, it should be determined in accordance with the normal civil procedures. In the present case, the Customs sought to treat the previous decision of the Crown Court as conclusive of any question which Mrs. Norris might raise. They did not at all enter on the merits of what she was deposing, etc." And so this case of Norris is emphasising the right of access to the civil courts unless it's being taken away, and it takes a clear and express provision to achieve that result. That's letter C on page 178. So that is the Norris case. Then the next one to look at is tab 10 in the bundle. It's the SFO and Lexi case. And there's some dicta in this case. If you look in the head note, above the head note again, on page 223, in italics, crime restraint order variation, third party creditor applying to have restraint order varied to pay judgment debt, whether entitled to seek variation, whether equitable charge attaching to all or part of the judgment debt, whether the restraint order be varied to allow payment from assets to which the charge attached. And then whether power to vary restraint order to allow payment of unsecured creditor, and then various provisions. And then there was some lengthy argument in that case about the interest. Lord Justice Keane delivered the judgment, 227, and he starts at 1, paragraph 1, by saying the appeal concerns the approach to be adopted by the courts to restraint orders under POCA when a third party raises claims which would reduce the amount of the restrained asset. So far as we're aware, it's the first case to reach the Court of Appeal Criminal Division raising such issues since the relevant provisions when the Act came into force. Everyone's contributed to the judgment. And then if we cut to the end of the conclusion is at page 242, paragraph 58. It follows from all this that in the judgment of the court, Lexi has an equitable charge and an interest for the purposes of the Act over 2 bank accounts, but no equitable charge over any other assets held by M has been established. And then they say that leads to the next issue, and that's headed the possession of unsecured third-party creditors. And so we're not concerned with that in our case. What they actually do is, if you go to the very end, there literally is, after their conclusions, a postscript, headed postscript, at page 252. We can't leave the appeal without commenting on some procedural matters which have come to light during the hearing. There can be little doubt that the issues which arose in this case concerning beneficiary interest, equitable charges and tracing were far from straightforward, not part of the daily work of most Crown Court judges, and indeed this constitution of the Court of Appeal Criminal Division was deliberately arranged so as to ensure that appropriate expertise in matters normally falling within the jurisdiction of the Chancery Division was available. Sometimes issues may arise in restraint order proceedings about equitable interest which are not unduly complicated and can be dealt with in the Crown Court. In other cases, the sums involved may not warrant any unusual steps, but there may be other times when the complexities are such that it may not be wise for the Crown Court judge to embark on seeking to decide the issues. In such a case, where a relaxation of a restraint order is sought, consideration should be given to adjourning the variation proceedings to enable the issues to be determined in proceedings before a specialist Chancery Circuit Judge or High Court Judge of the Chancery Division, alternatively listing of the cases in the Crown Court. So that alternative, which is adjourning the Crown Court proceedings to enable issues to be determined by a specialist Chancery Judge or High Court Judge of the Chancery Division, that's at odds with the paragraph 33 in this judge's.
The language of that postscript is quite close to the language of the note to the 2015 Act that took us.
Yes.
I haven't cross-checked it, but the first half of it.
Well, but it can't be. Oh, well, unless it's the other way round.
Other way around.
The other way round, yes.
I mean, I haven't cross-checked it, but as you were reading it, I was thinking, I've heard this before, and the only time I've heard it possibly is in that note that you took it to. Anyway,
Yeah.
we can look at that in due course.
Okay. Well, that's the first case reaching the Court of Appeal Criminal Division about the Act. Then, if we go on to the next tab, 11, there's another chunky judgment in the Stanford case. Obviously, Mr. Stanford was a rather.
Is he the cricketer?
He was involved in cricket.
Yeah.
in interesting
Cricket
ways.
enthusiast.
Yes. He features in documentaries and the like, but this is the end of the story when the scheme has all gone unravelled. And if you look in the above the head note on page 254, the first line or so in italics, crime, proceeds of crime, recovery of assets, external request for restraint order over the bank's assets in England and Wales, restraint order granted following an ex parte hearing. And then there are some dicta in this case, which you get right at the end, actually. So if you go to, perhaps I don't know whether I should go to, yes, if you go to page 333, paragraph 204, there's a heading, Practice, Restraint Orders and Concurrent Civil Proceedings. This is a good example, but by no means the only one, of the manner in which an application for restraint order under POCA may interlock with complex issues which arise in other litigation. It provides an opportunity to consider the best methods of managing the applications. Prior to POCA, all applications for restraint orders under either the Criminal Justice Act or the Drug Trafficking Act had to be made in the High Court. Now, by virtue of certain sections, the jurisdiction is committed to the Crown Court. The same court has the only jurisdiction to vary or discharge a restraint order, see section 42. Subsections 58.5 and 58.6 plainly contemplate that other litigation relating to property, which is subject to a restraint order, may, as a result of the order, need to be stayed or permitted to proceed only on terms. Accordingly, the initiative is firmly in the hands of the Crown Court. Not sure the last.
I was going to ask you whether
I
works.
I agree with the contemplating that you've got civil and criminal proceedings. Why do you say the initiative is in the hands of the Crown Court? I'm not so sure.
I think it's maybe using the word initiative to mean that the dominant role.
Well, it might be. I mean, it's not ready for me to. Lord Justice Hughes would know far better what he meant than me, but it might be the Crown Court judge thinks that this is a bit complicated and suggests to one of the parties that, you know, the interested party who's somehow managed to get to the stage of appearing in front of the judge. You see, it's not that easy because you've seen isn't some, you can't insist on being joined or something of that kind. So and you don't even get to see the papers. You'll see right at the end of my submissions when I take you back to the note that you don't see all the papers that goes on because there's a public interest here. It's the Crown versus the defendant.
If you have a situation where both proceedings are in being, and the Crown Court takes the view that something is just too difficult for it to take,
Yeah.
then it can just stay the POCA proceedings or stay the issue to the civil court.
Well, it might be. I mean, I look to Lord Justice Coulson, who obviously knows a bit about this, that it may be that what happens is that these are exceptional circumstances for the confiscation order not to carry on for a while.
Maybe going it a bit.
Well, the problem is if the Crown Court judge says, well, I'm going to hold my hand now, because I can't make the 10A only works when you're going to make the confiscation order. So it's very linear. But obviously a civil court can come to a decision on different dates. And so you say, well, I'm going to leave it to the civil court to give me a ruling as to who has what interests and how you quantify them. So you could do that, subject to the overall limit on the confiscation order. Anyway, I paused because I wasn't completely sure about the final sentence. It doesn't follow that efforts should not be made to achieve two aims where possible. The first is to do what's practical to match suitable judicial expertise to the case. The second is to manage restraint order applications and associated litigation so far as can be accomplished in a coordinated manner. Many applications for restraint orders are made in circumstances of urgency and ex parte, and then they must be made to whichever judge is available in the Crown Court. There's expertise at Southwark, and then there's a reference back to the Lexi, which I took you to, and then this case, the Sanford case, had contested Antiguan winding up and American receivers, and so there's. I wasn't going to read all the flagged section. If you go to paragraph 211 and the final sentence, the decisions involved are matters of pure case management and are most unlikely to generate appealable rulings. That's some decision. Perhaps I should have read the whole 211. The judge eventually hearing a restraint order proceeding should ordinarily have some experience of criminal cases, the nature of the confiscation regime and the manner in which prosecutions and defence proceed. No reason why a judge of the High Court shouldn't sit in the Crown Court to deal with a complex restraint order case. He or she may be from the Queen's Bench, Chancery or Family Division or Commercial Court. Some cases may be suitable for hearing by a specialist judge. The presiding judge will be in a position to consult the appropriate head. Now, the interesting thing that is you don't get out of this any statement that we can't have this case management because it's all in the Crown Court. You know, you can't have the Parliament, as by POCA, has said it must all go to the Crown Court. That's not a practical, one of the other problems we have is that Parliament surely couldn't have intended that, because all these helpful comments made about case management don't work if you sanction the words of paragraph 33 of the judgment.
I mean, there are two separate points, really, aren't there? I mean, you're relying on this to show that the Court of Appeal was envisaging what it says in the heading, concurrent civil proceedings, at least in certain cases. And that's the real point. The question of expertise is a slightly different point,
Yeah.
and is a question of as Lord Hughes says here, a question of case management. But certainly speaking for myself, I wouldn't want it thought that expertise was something that could not be found in the Crown Court. I mean, some Crown Court judges effectively specialise in POCAs, and when one sits with them in the Court of Appeal Criminal Division, one is eternally grateful for their knowledge and expertise. And I notice at paragraph 207, he picks out the Crown Court at Southwark. The best POCA judgments I've ever read were all produced by Crown Court judges sitting at Southwark.
Yeah.
So I think the expertise point is a separate point. And speaking for myself, I just simply don't think there's anything in a suggestion that Crown Court judges can't deal with this work. But that's a separate point, and it shouldn't detract from your principal point, which is that you can have concurrent proceedings as this judgment demonstrates.
Yeah, right. I adopt all that you've said. So that's Stanford.
Well, if Stanford is a correct statement of the law in 2011, we've got to find something in the 2015 amendments that changed the whole game.
Yes. Now, we then come to Maloney Friends sheet anchors, I think I've called it, which is the Kappa case, which is at tab 12. There is a dispute between Maloney Friend and I as to the ratio of the case, and in any event, I say it was concerned with different provisions of POCA to do with cash. There are comments made by Mr. Justice Lewison, as he then was, about the exclusive jurisdiction principle, but not focusing, as we are, on property points. And so I say that this case is distinguishable. And if really pressed, I would say it's wrong, but there are a number of strands of reasoning in this case. It wasn't just reasoned out on the point that we are concerned with in this case. Now, so I'm going to spend slightly longer on this case because this is Maloney Friends, as I say, his sheet anchor, and so I'm going to look. We just go straight to the judgment rather than the head note. Page 337. The Metropolitan Police are investigating money laundering. They go to some safe deposit boxes in Finchley Road. They have a warrant. They seize cash from one of the boxes. It's been rented by a Mr. Cheney, and the police find £330,000, and then they re-seize it under Part 5 of POCA, and then the Magistrates' Court make an order under Section 295 detaining the cash on the grounds there's reasonable grounds to suspect the cash was obtained through unlawful conduct or was intended for use in unlawful conduct. Paragraph 2, in the meantime, Mr. Kappa claims that most of the cash was his, and he applies to the magistrates for the release of £250,000, which he says belongs to him. And he gave evidence in support of the application. Mr. Cheney consented to the release of the money, but didn't give evidence. The district judge refused the application. He was not been satisfied that Mr. Kappa owned the cash, and he was not satisfied grounds for suspicion had ceased to exist. So then, Mr. Kappa issues proceedings in the Chancery Division. By his Part A claim form, he claims a declaration he's the beneficial owner of the £250,000. And it's then explained the roles of the different parties in that. Mr. Master Bowles refuses the application to strike out or stay the claim. And then if you look at paragraph 4, section 204 of POCA describes the general purpose of Part 5 as follows. And you'll see this is all about cash. This part has effect for the purposes of enforcement of authority in civil proceedings, enabling cash, which is or represents property obtained through unlawful conduct or is intended to be used in unlawful conduct, to be forfeited in civil proceedings before a magistrate's court. 2 points emerge from this. POCA allocates jurisdiction in respect of the recovery of property to the High Court, allocates jurisdiction over the forfeiture of cash to the magistrate's court. 6, there's a reference to the constable suspecting cash is recoverable property. Paragraph 7 talks about cash. Paragraph 8 talks about cash. Paragraph 9 talks about cash. Paragraph 10, there's section 294, which is all to do with forfeiture of cash. And section 301 in paragraph 11 is all about cash. And then you get to paragraph 13. 4 points can be made. First, it doesn't prevent the magistrates from adjudicating between rival claimants to the cash as long as the person from whom the cash is seized doesn't object. It applies only to section 301 and doesn't prevent the magistrate from deciding complicated ownership disputes when deciding whether to order cash to be forfeited. It doesn't help Mr. Capel on the facts of this case because Mr. Cheney didn't object to the application. Fourthly, even though the person from whom the cash was seized doesn't object, it must still appear to the magistrates the cash belongs to the claimant before they can release it. The court must scrutinise the claimant's case and must, if necessary, apply concepts of property and ownership to decide that question. Master Bowles decided there was nothing in POCA which excluded the ordinary jurisdiction of the High Court to determine civil claims. His starting point was that the issues raised by the claim form were straightforward, private law issues to be determined by the High Court, and Mr. Capper shouldn't be denied the right to bring his claim without a scrupulous examination of all the circumstances. And then there's quite a long discussion about the view of Master Bowles, who left the case as it was. And then if you look at the submissions by the Commissioner at 15, the Commissioner's argument on appeal can be summarised as follows. Parliament has provided an express statutory remedy for cases where cash is seized by the police and a person claims to be the innocent owner. The only purpose and intended effect of bringing the proceedings was to gain a litigation advantage in the cash detention proceedings, and bringing these proceedings is therefore a classic abusive process. And then the Master said, I'm not persuaded the authorities relied on the Commissioner make good the broad proposition that in circumstances where a statutory scheme has been enacted to deal with a particular question, the High Court should for that reason alone decline jurisdiction. And then the judge says at 17, the Master may have been justified on the basis of the authorities that were cited to him, but he wasn't referred to the line of authority dealing with the jurisdiction of the High Court in relation to questions within the competence of the Commissioners for Income Tax. If he'd been referred to this line of authority, he would have come to a different conclusion. The most recent authoritative statement is AutoLogic, and then we've got AutoLogic set out. And 19 says, in the present case, Parliament has assigned the resolution of disputes about cash to represent proceeds of crime to the Magistrates' Court and on appeal the Crown Court. Mr. Capper's claim in the High Court to ownership of the cash is an indirect way of seeking to achieve the same result as will be open to him by presenting his case to the Magistrates' Court when the Commissioner's claim to forfeit the cash is determined. As Lord Nichols said, it's an abusive process. The Master's decision began from the wrong starting point. And then you've got the residual discretion point, which is the quotation from Lord Justice Robert Walker. And then 21, before the Magistrates' Court, the essential factual issue is whether Mr. Capper or Mr. Cheney is the owner of the cash. The issue raised in the High Court is precisely the same. Thus, even if the Magistrates' Court does not have exclusive jurisdiction, the High Court ought as a matter of discretion to decline jurisdiction. Disagree with the Master, the issue is not the same. But even if he was in very formal terms right not to go on to consider how closely the issue in the High Court proceedings approximated to the issue before the magistrates. So we're into other types of abuse here. And then there's reference to procedural advantages, which the judge is not impressed by. And then there's a bit more sidelining that I will take you to at 24, after it being suggested that it was right that there should be private litigation. Mr. Justice Lewison is not impressed. He says at 24, it's a preposterous submission. No dispute between Mr. Capper and Mr. Cheney. 3 months before the proceedings were issued, Mr. Cheney had already consented to the release of the cash. He said in his acknowledgement he didn't contest the claim. He provided a witness statement. If and when the fund is released from custody of the Commission, and there's no reason to suppose he will refuse to pay it over to Mr. Capper, if that is what Mr. Capper and Mr. Caney agree. The finite resources of the court should not be wasted on dealing with an illusory dispute. In addition, if, as Mr. Capper said, no claim is made against Mr. Commissioner, why join him? The answer is Mr. Capper wishes to use a decision of the High Court to create an issue estoppel. In other words, Mr. Capper's real objective in bringing the proceedings is to preempt a decision by the magistrates on a question that Parliament has entrusted to them. In my judgment, the use of the procedural machinery of Court A to achieve a result in Court B, where Court B is a domestic court competent jurisdiction, is properly characterised as a collateral objective. The remedy which we seek is no practical use to him, etc. In addition, Mr. Capper has already tried and failed to persuade the magistrate that he is the owner of the cash. Either that's an issue estoppel, or if not, it's an additional reason why it's an abuse. And then he says at 28, I've decided whether to stay rather than strike out, but there is no point in a stay. So there are significant factual differences between this case and our case, and not least to say because it's all focusing on cash, it's focusing on what went on. And this is, although there's more than one strand of reasoning there is nothing that I suggest this court can say, even if Mr. Justice Lewison was sitting as Lord Justice Lewison with two other judges, you can't say there's something in this case which is binding on this court to come to a different decision from the one that it should come to on the basis of all the other material. So I invite you, as I say, to distinguish this case.
And the distinction is because this is dealing with the very self-contained provisions about cash.
Yes.
Full stop.
That's the simple way forward for this. That's right. That's probably the best way.
I mean, one theme, as you say, there's more than one theme in the judgment. One theme is, well, the real dispute is between Mr. Capper and the police.
Yes.
There's no real dispute between Mr. Capper and Mr. Cheney. Now, can it be said similarly here? There is no real dispute between your client and Mr. Tatum. It is a dispute between you and the CPS.
Well, that as I said at the outset, that's a strand of reasoning that I think probably was being advanced by my learned friend, but wasn't the basis of, I suggest, of the judge's decision. The judge's decision, which is paragraph 33, that's the issue. It's almost as though my learned friend wins too well. Instead of limiting his submissions to ones that have some elements of the Capper case, he goes all in by saying this is an exclusive code and it's all down to the Crown Court. Now, the attraction of that submission, if accepted by this court, is obvious that this decision can be used to deflect so many third-party claims, whether they're meritorious or unmeritorious, I'm leaving to one side, because it can be then said, let's deal with it all in the Crown Court. Now, moving on, tab 14 is the Chella Pamal case, in which Mr. Evans was the only counsel to appear. He appeared on behalf of the FCA, and the claimant and nobody else was represented. And sufficient to say, I'm not going to spend a long time on this, because the master had 4 primary reasons advanced to him as to why this was an abuse. If you go to paragraph 9 on page 374, you can see it says the FCA say the claim is an abuse for 4 primary reasons. 1, it's an attempt to relitigate an issue already decided. 2, it's an attempt to bypass the statutory scheme. 3, it's collateral objective in bringing the claim. And 4, the second defendant is driving the application. And then all those points are examined in the judgment, and the master is persuaded, because there was effectively no contrary argument, accepts all of those. So the case is brought to an end. I mean, factually, it's a long, long way from our case, where there were various remedies were followed up and failed. There was a right that could be followed up. It wasn't followed. So if ever there was a case where you were expecting the matter to be struck out as an abuse, it's this sort of case. So it doesn't really add to the jurisprudence for this court to consider. I then come to the last two cases. Tab 16 is the Forte case. Quite an interesting case, the Forte. I read it with some concern because you had confiscation proceedings in the Crown Court. The defendant and his former wife did not give evidence. The judge drew adverse inferences, and the Court of Appeal dismissed the appeal. And no, sorry, I'm very sorry. I've missed out one case. Can I move back? Because I'm quite keen to deal with these in chronological order. This is the case that I thought was strange. Can you go back to tab 13? I'm very sorry.
13.
13, yes. Page 346. It's the Gullum case. Realised as I was reading my notes that this Gullum case was an appeal from the Crown Court by a third party, Mr. Butt, who claimed an interest in real property. And the appeal involved criticisms of the conduct of the barrister who was representing Mr. Butt in the Crown Court, including allegations that the barrister was incompetent. But one of the curious things about this case is that legal privilege was waived, and the Court of Appeal heard oral evidence from various witnesses, including the barrister. And they believed the barrister.
Where allegations of incompetence are made in criminal proceedings, it's conventional for privilege to be waived. Then very often one has to. It's quite rare that there's oral evidence, I accept, but you do quite often. The judge often has to form a view as to the level of competence or otherwise.
Right.
Sorry, I interrupted. Joe, you were saying that there was oral evidence.
There was
from
oral
the
evidence
barrister.
from various witnesses, including the barrister.
Yeah.
The Court of Appeal believed the barrister, and they rejected the appeal. So the reason I'm taking you to this case is because there were some brief comments on section 10A right at the end. So if you go to page 371, I think I can read from paragraph 90. We bear in mind that section 10A has only recently been brought into effect, and there was no case law giving detailed guidance as to its application. We conclude, therefore, in the circumstances of this case, that the judge did not make a determination under section 10A, and Mr. Butt accordingly did not have a right of appeal. We have in any event indicated our reasons for concluding that even if a determination had been made, Mr. Butt would not have succeeded in bringing himself within either section 31.6 or 31.7. And then we've got the little case management comment. We would add, with a view to helping judges and recorders in the Crown Court, that where there is a claim by an interested party, the court should make clear whether or not it thinks it appropriate to make a determination under section 10A and give reasons which may not need lengthy exposition for that decision. In such a case, it will be necessary for care to be taken in completing forms 5050 and 5050A so as to reflect the court's determination or decision not to make a determination. And then they say they've refused applications for extension appeal. And so there's an order for costs. And so there are some comments in 91 that probably would don't sit well with the judge's view of paragraph 13. I'm sorry I took you out of order in relation to that. So that's the Gullum case, and that was judgment in July 2018. Then we've got Forte, which is tab 16, and that takes us up to 2020. And then, as I was starting to tell your lordships, in this Forte case, there were confiscation proceedings in the Crown Court. The defendant and his former wife didn't give evidence. The judge drew adverse inferences, and the Court of Appeal dismissed the appeal. there are some important comments in the Court of Appeal judgment that there could be civil proceedings in parallel with the Crown Court proceedings. And it's those comments that are pertinent. So if you go, it's paragraph 10 on page 414, it's sidelined. So it's necessary to observe the very significant difference conceptually between the position of a defendant and that of a person involved under section 10A1B in the proceedings, and now appealing under section 31(4) and 5B. The defendant is subject to the court's powers to sentence him and deprive him of his property because he's been convicted of a serious criminal offence, which has caused substantial loss to his victims. The Crown Court exercises its statutory powers to make the orders which it considers appropriate in the public interest. His appeal can succeed only if the result is manifestly excessive or wrong in principle. It seems to us these two broad tests capture the grounds on which sentence appeals are allowed, though it's possible to subdivide them further, see Archbold. Ms Vale, on the other hand, is in the same position as any litigant whose ownership of property is in issue. She has been convicted of nothing. She is not exposed to any penal consequences. There is no finding she was aware that Mr. Forty was committing fraud, but even if there was, in the absence of any conviction, her property rights would be unaffected. Civil proceedings to determine the extent of her beneficial interest in Hillside Lodge or her mother's interest in funds held in a bank account in her name might arise in many ways. They would be differently constituted from these Crown Court proceedings and governed by the civil procedure rules, which require statements of case, service of witness statements and disclosure of documents and so on. The procedure in the present situation is different. Section 10A2 of the Act requires that Ms Vale must be given a reasonable opportunity to make representations. Then there's a reference to the criminal rule, repeats this requirement, as the rule gives the court a power to order Ms Vale to give the information in such manner and within such a period as the court directs. Otherwise, the Crown Court procedure is not prescribed. So the reason I'm citing this is picking up the same thread as the law just now, is that there are probably 2 points engaged. The real reason I'm citing this is it's contrary to the notion that you can't litigate in the High Court if there are proceedings, confiscation proceedings in particular, in the Crown Court. These observations would simply be wrong if presented and put side by side with paragraph 33 of the judgment. And the last case.
You said there were 2 points. Is it?
Well, the other point is how, you know, the other point is just procedure. There are ways, in fact, they don't really develop it very much.
Yeah.
They say you can have civil procedure. They don't even go as far as we saw in the earlier case of saying giving case management directions or something. So there are useful dicta to a degree in these cases, all inconsistent with the decision, the ruling of the judge, but the exact way in which everything should be really done has not been spelt out. In this case, I don't need to spell it out. I perceive that I need to persuade you the judge was wrong in the basis of his decision, and then we'll come on to what I suggest. This is near the end now, what should happen. But before we come to the end, which I think I will reach just before the lunch adjournment, if I can mention the Aquila case, which is, I think this is why I was thrown a bit. One of the cases is out of order. So yeah, the Aquila case has been put in at tab 15, whereas in fact it's more recent. It's November 2021. It's page 387, tab 15. And it's one of these cases involving directors who were fraudsters. Who, if we look at the head note, and I think it is necessary to look a bit at their head note. 2 directors of a company, VT Limited, exploited their position as directors in breach of fiduciary duty and made secret profits of just over £4.5 million through the promotion of fraudulent tax avoidance schemes. They were convicted of having cheated public revenue. The Crown Court found the directors had benefited from their criminal conduct in the sum of £4.55 million, made confiscation orders against them pursuant to POCA. The claimant, a company which had acquired the interests or the rights of VT Limited, sought a declaration from the time of its receipt that the 4.5 million had been held by the two directors on a constructive trust for VT Limited. The judge granted the declaration sought. The Court of Appeal dismissed an appeal by the CPS, which brought a further appeal on the grounds that the fraud of its former directors should be attributed to VT Limited, so as to prevent the claimant, by reason of illegality, from relying on a constructive trust in priority to the claims of unsecured creditors such as the CPS. And the regime of the Act should not permit the claimant to benefit from the profits generated by the fraud of the former directors. And the appeal was also unsuccessful. And reading the head note, where a company brought civil proceedings against its directors to recover the proceeds of crime, which the directors acquired in breach of their fiduciary duty, claiming that the sum so acquired was subject to a constructive trust in the company's favour, the unlawful acts or dishonest state of mind of those directors could not be attributed to the company, notwithstanding that the company had suffered no loss and stood to profit from the illegal act. And therefore the company could not be said to have acted illegally, and its claim would not be barred by the defence of illegality. The fraud of the two directors could not be attributed to VT Limited. And then the second part is probably particularly important. I'll read it here and then see the passage. The scheme of POCA was not to interfere with any third-party property rights except tainted gifts, and to protect such rights regardless of how they arose. A determination of the assets of an offender in respect of whom a confiscation order had been made was subject to a constructive trust in favour of the third party was not consistent with the aim and purpose of the Act. It followed that the declaration granted by the judge was not inconsistent with the regime established by the Act. And Lord Stevens, as you'll see from page 389, appeared there, and you'll see, in fact, Mr. Evans appeared as one of the counsel on behalf of the ultimately successful claimant. Lord Stevens, with whom the other four judges all agreed, delivered a judgment, and the key passage is at page 394. And there's 2 pages which are sidelined. Without reading all of them out, because there's an overview. The judge says he wants to detail the provisions of POCA. If you look at 33, the overarching principle of POCA is neither a confiscation order under Part 2, nor a civil recovery order under Part 5, nor the money laundering provisions in Part 7 interfere with existing third-party property rights. That's a very important statement of principle. And then at the end of 33, just below F, POCA reflects the approach of the Drug Trafficking Offences Act, which preceded it, and of which Lord Hobhouse said in setting out the scheme of the Act, that confiscation orders should not interfere with the property rights of innocent third parties. So that's a sort of general principle that we say is the backdrop to how you will construe, or we invite you to construe the Act. So that's my references to the case law. So under the heading summary, what do I say are the questions to be asked and the answers? First question is, was the judge at paragraph 33 correct? If he was correct, then the appeal is dismissed. If he was incorrect, then he misdirected himself. So what should this court do? Well, when the High Court began, the High Court case began, Mr. Tatum's trial was still being awaited. So the proper forum for determining that was the civil proceedings. We say the CPS was wrong to issue a strikeout application. But of course, the position's changed now. There are confiscation proceedings underway in the Crown Court. And I probably now should just take you to where we are in relation to that. I hope that your lordships have all been provided with a copy of the supplemental skeleton. And next to it was an exchange of emails, which shows that although it hasn't got a heading on, I enclosed the emails because I haven't quite come across the notion of a judge's order that doesn't have a heading on or something. But anyway, you can see the provenance of a document headed confiscation, which comes from His Honour Judge Edmonds, who is the judge handling this at Isleworth Crown Court. And what happens is he seems to have sent a note to Junior for the CPS. And then the first part of the note, it says Mrs. Tatum represented. Gardner, he's a co-defendant, so you can put a line through that, that's not relevant. And then there's a reference to the 2-year period, that must be the normal period for confiscation. DT to file and serve evidence on which he intends to rely by the 15th of April. Warning re-inferences to the evidence served at the last minute. CPS is going to file its evidence by the 13th of May. And then it says, Ms. Emmett to be joined to these proceedings for the determination of any claim as to her interest in any of the defendant's realisable property, and then in brackets contingent on the outcome of this appeal. Mrs. Ahmet cannot be provided with access to the DCS, which, as I told your lordships, is the digital case system. Prosecution and Tatum to serve on Miss Ahmet their respective POCA documentation served so far by the 19th of February and thereafter with supplemental documentation. Prosecution are to upload such materials as are served by Miss Ahmet. So it looks as though prosecution and Mr. Tatum, they have everything, she doesn't. And then if you carry on over the page, Miss Ahmet to set out her claim by a witness statement by the 15th of April, to include evidence on which she seeks to rely, to include documentation which undermines their case or supports another. In the event that the appeal succeeds and her claim proceeds in the High Court, she is to file or serve material relating to gifts made by DT, in particular about Brindle's farm. And the CPS is to provide any further documentation, and then there's going to be evaluation. And then if you drop down, there's a hearing for a final order on the 29th of July with a time estimate of 2 to 3 days. And so we say if the appeal is allowed, then the High Court proceedings will be restored, and those High Court proceedings then are subject to such order made on application as might be made under whatever it was, section 58(5). Yes, section 58(5), which is page 63 of the bundle, and we've already been through that. And so the and I don't know, it would be a matter for your lordships to inquire if you see fit, what the position of the CPS will be if the decision is taken, the appeal is to be allowed, what then directions are to be made. My principal object in presenting this appeal is to seek to persuade your lordships paragraph 33 is going too far. Those are my submissions.
I don't detect any more questions for you, and it's almost 1 o'clock. So thank you very much, Mr. Warwick. Sorry, yes.
Can I just ask one thing, which is for Mr. Evans after lunch, really? Does the, if, however it's expressed, a third party becomes involved in POCA proceedings in the way that's been discussed this morning, is there any provision for them to be awarded their costs if they're successful? So if, for example, Ms. Ahmet participates in the POCA proceedings, however it be described, and the end result is a determination that she's right and she has the interest for which she's been contending, either is the jurisdiction, or also is there a normal course of conduct which Mr. Evans would know about, and I certainly don't.
We'll break then and resume at 2 o'clock.
Court round if able.